Driving while suspended after a prior conviction for the same.
Guilty.
By pleading guilty, you're admitting that you were speeding 80 and a 65 and driving while your license was suspended after a prior conviction for driving while suspended?
Yes, ma'am.
And are you admitting this because you believe you are in fact guilty of those two charges?
Yes, ma'am.
Is anyone making you enter this plea today by any threats or promises other than your plea agreement?
No, ma'am.
Do you understand you're giving up your right to trial, including the jury trials we had scheduled for Wednesday?
Yes, ma'am.
And that you'll be found guilty and unable to appeal your conviction. Do you understand that?
Yes, ma'am.
Okay. And were you driving in Butler County as alleged on August 28th to 24?
Yes.
Do you remember what highway you were on?
The back road between Winfield and Rock. Well, it was between Winfield and Augusta, so I was on my way to work.
So if on the citation, the officer, which would be Master Trooper Brian Grunder, said it was on Highway 77 at mile marker 36 north in Butler County, would you agree with that or take issue with it?
No, I would agree with that.
You'd agree with that? Very well. And that was a 65 posted and you were driving 80. Is that what you're telling me?
Yes, ma'am.
All right. And you had that prior conviction for driving while suspended.
Yes, ma'am.
All right. I accept your plea in 2287 and find you guilty. I do, pursuant to your plea agreement, dismiss with prejudice case number 2024 TR 2728. Those case numbers are quite similar, but you have been found guilty in 24 TR 2287. Recommendations for sentencing, Mr. Regier.
Yes, Your Honor. Pursuant to plea negotiations in 24 TR 2287, the state is recommending the scheduled fine and court costs for the speeding for the driving while suspended. The state is recommending a $100 fine, court costs deferred to the court on the issue of attorney's fees. The state is further recommending a year of reporting probation, subject to a $60 probation fee and a 6-month underlying sentence. The state is further prepared to recommend a 10-day house arrest in lieu of the 5 days in jail. Also, although I understand this was not specifically discussed during the context of plea negotiations, it would appear that at the first hearing in this case on December 4th, 2024, the court did issue certain orders concerning booking and bond. I do have an affidavit from the jail that would appear to indicate that as of January 17th, 2025, the defendant failed to report to the Butler County Detention Facility as directed by the court to be processed and released. The state does acknowledge that there have been at least one recent hearing since the date of that, most recently on March 31st, 2025. However, the state has not been able to confirm that there have been any appearance bonds executed in this case.
Mr. Patterson.
Your Honor, as far as sentencing, we'd ask court to adopt the recommendations. We would also ask court to allow the 10 days house arrest with work release. As far as the bond issue, I haven't researched that. And also, I don't know that I was present when it was ordered, but so I don't have any information on that part of it.
Ms. Hushaw, before I even proceed to your sentencing, why should I not find you in contempt in both these cases for violating my orders to go out and get your picture and prints and bond? Why should I not have you serve jail time and pay a fine on that before we get to your sentencing?
I thought I had went out there. I went out there and got fingerprinted for something. I thought it was this case, but this was the only 2 cases that I know of that I have in Butler County. And I went to El Dorado once just to get my fingerprints done, but other than that, I wasn't aware I needed to go again.
Is CLW, Jen, a county, or is that Clearwater, the city? If you know. Do we have a county CLW?
Your Honor, I do not know.
All right. Well, Ms. Hushaw, it looks like you have something pending in another jurisdiction and yet another jurisdiction and in Butler County. And you have a long, long history of traffic violations. So it is possible that maybe you mixed up getting your fingers and prints taken in one of those other jurisdictions. Court security, are you available?
Yes, Your Honor.
Do you have any way of finding out fairly quickly if she had any picture prints taken in either of these cases?
And Your Honor,
Mr. Regier?
one thing I might add for clarification, in the 24 TR 2728 case, I am showing an appearance bond in the amount of $2,500 on recognizance. But again, I have been unable to confirm whether or not any appearance bonds have been successfully executed in the 2287 case. And that it would appear that the jail affidavit I had previously referred to on the record is in reference to that particular case.
All right. So it sounds like you went out maybe on one but not two. Deputy?
Our control is out to lunch, but I'm trying to figure it out.
And,
Okay.
and I just would point out, Judge, that doesn't make a lot of sense to me. That the one that I'm told now that she has a bond in happened in August. And the one that she doesn't have a bond in happened in August. The one she does have a bond happened in October. How's it she got a bond in the later one and not the earlier one? It seems like when she go out to jail, they'd do both of them at once.
Unless, I don't know.
And Your
I
Honor,
don't know how they do that. Mr. Regier?
what I would tell the court is that the amended information in the 2728 case does appear to refer to an alleged occurrence date on October 10th, 2024. It would appear that the first appearance hearing on that case was in January of 2025. In the 2287 case, the amended information does appear to refer to an October 28th, 2024 occurrence date on the information. However, I'm not, and it does appear that the first appearance in that case occurred in December of 2024. I'm not sure if that helps the court or not in this.
Well, I think it answers Mr. Patterson's question. The one that she got first, she appeared on later for whatever reason that happened. So, well, I don't know, Ms. Hushaw, about giving you probation if I can't trust you to comply with my basic orders. I don't know that makes you a good probation candidate.
Is there not any other time I'm able to go out there? I can go
That's
out
not
there
the
today.
point. That's not the point. The point is you didn't do what I told you to do when I told you to do it. Let's see what court security says, if they can get us an answer in a timely fashion.
I honestly thought that when I went out there, it was taking care of both of them. That's my mistake.
You hadn't even been to court on the one before you went out. Deputy?
10-4.
All right, Deputy, what did you find out on that warrant?
She was
24?
processed in January. I'm not sure which case yet, but she was processed in January of this year.
And Judge, again, that goes to my point. She would have had first appearances on both cases. Why didn't they do it both at one time? I mean.
Mm-hmm. All right, well, here's what I'm going to do, Ms. Hushaw. I'm going to follow the recommendations, and I'm going to order that you go out there as a condition of probation and get both of them squared away. And if you don't, you'll be in violation of probation, that probation can be revoked, and you can serve any sentence that I impose herein. So let's proceed with sentencing in 24 TR 2287 for speeding 65 in an 80. I impose the scheduled fine of $75. Because this is an infraction, there will be no jail time. On count 2, driving while suspended after a prior conviction for driving while suspended, your fine will be $100. Your sentence will be 6 months in jail. Where do you work?
I'm an assistant manager at the Wendy's in Derby.
All right. You will be ordered to pay $250 of your court-appointed attorney fees. You will be ordered to pay $108 court costs. You'll be ordered to pay $60 probation supervision fee. Your controlling sentence is 6 months, but if you don't want to serve that, you will need to successfully comply with the reporting probation I'm about to give you. All standard conditions will apply, and they will give those to you. You must call probation as soon as this hearing is over, although they very well may be at lunch, as it is now 12:11 p.m. If you do not get an answer, leave a message and call again after lunch. It is your responsibility to call probation. It is not their responsibility to chase you around and send you letters and call. If you miss your appointment, that's on you. It's not enough to say, well, I tried to call them back and they never returned my call. It is on you that you must appear when they tell you to. I'm telling you to call them, and here is the number. 316-322-4153. Call them today. Your probation includes that you complete the mandatory 5 days in jail. Are you wanting to do that in 10 days as house arrest instead?
Yes, ma'am.
I will give you 10 days house arrest, but you must have the electronic monitoring on and begin that house arrest within 7 days of today. You are not to leave your house for any reason except to go to work and come straight home. Don't stop and get a Coke. You will have that bracelet on, that ankle monitor. Mr. Aguirre, anything else I need to address other than dismissing the other case as part of the plea agreement?
Your Honor, if I misheard, I apologize. Is the court ordering that the house arrest, subject to electronic monitoring, work release commence within 7 days of sentencing?
Yes.
And Your Honor, is the court setting any, or rather is the court making any orders concerning the length of the reporting probationary period and the manner in which the case is to be paid?
The probation will be for 12 months, starting today. The money owed must be paid at the rate of 1/12 per month until paid, and the first payment will be due on June 19th, 2025. 1/12 will be due on the 19th of each month thereafter, again until paid in full. Anything else, Mr. Regier?
Just one final point, Your Honor. Is the state's understanding correct that notwithstanding the plea agreement which contemplates the dismissal of 2728, is the court ordering booking and processing in both cases for purposes of finalizing the journal entry?
The court is ordering.
Judge, looks like court security might have some information.
Deputy?
Your Honor, it looks like she was processed on the 2728 case, but she was not on the 2287 case. So I'd need a bond amount, and I'll schedule her to go out and get that done.
She has been convicted and it is being ordered as a condition of her probation to get out there and get that done, so she won't need a bond. But you need to, I'm ordering you as a condition of your probation. He's going to give you an appointment, court security is. Keep that appointment or you're going to be in violation of your probation and you can get your probation revoked.
Yes, ma'am.
All right, look, anything else from either counsel, Mr. Patterson?
Nothing further.
Anything further, Mr. Regier?
No, Your Honor.
All right, Ms. Hushop, go into the breakout room with the officer, get your
Your
date.
Honor,
Yes, sir.
I don't have another person here, so if I could just give her a date right now, that'd be great.
Go ahead.
Okay, Ms. Hushaw, need you to go out there on Thursday. You want morning or afternoon?
And Thursday should be afternoon. Wait. Sorry.
Afternoon?
Actually, if we could do morning then, that would be great.
Okay. Thursday at 10 o'clock.
Okay, 10 a.m.
Go
So-
to jail and just tell them you need to be fingerprinted and pictured because you took a plea. You don't need a bond.
Okay.
And I'll make sure I let them know.
Tell her that address, please.
It is 701 Stone Road in El Dorado. 67042.
If you get off the turnpike and head straight down 254 that becomes Central and keep going past El Dorado, it'll take you right there to the jail on Stone Road. You'll see the sign, right? If you go to the prison, you've gone too far.
Okay.
But you're going to call probation and get that set up as well. If they want to transfer that to your home county, do you live in Sedgwick?
Uh,
Okay. Transfer that to Cali, they certainly can do that. But those are the orders of the court this time, and if there's nothing further, we'll be in recess.
thank you.
You're welcome. We'll now be on the record in BU 2024 TR 1551, State of Kansas versus Jennifer Lynn Jester. Jared Regier for the state, Darren Patterson for the defendant. Jennifer Jester.
Your Honor, this is a case where she is not on here. I don't have an explanation of why she's not on here, and we do not have a current phone number for her. The one we had is not in service, so I don't have an explanation of why she's not here.
Charge is driving while suspended after prior conviction. Recommendations, Mr. Regier.
Your Honor, this is a case where it would appear that a $2,000 professional surety bond was executed in this matter. Based off my notes, I am not showing, it would appear that there was an attempt at service that was unsuccessful back in August of 2024. However, I'm not showing that I'm not sure if the court considers that a failure to appear, but at least after that, there have been no failures to appear. Nevertheless, the state does note for the record that this matter is scheduled for a jury trial, as the state understands. Additionally, it is the state's understanding that subpoenas at least one subpoena was issued and the state's witness was served. For that reason, the state is recommending a bench warrant bond forfeiture, no bond hold.
When someone sets a jury trial and then they fail to appear for pretrial or jury trial, this court believes no bond hold is appropriate. So I'm issuing a bond forfeiture, a bench warrant, and new bond will be withheld until she sees the judge. So no bond hold. 24 TR 2141, State of Kansas versus Charles Richard Kellogg. Jared Regier for the state, Darren Patterson for the defendant, who appears in person on one count of DUI. Mr. Patterson.
Thank you, Judge. I would announce at this time, pursuant to plea negotiations, Mr. Kellogg will enter a plea of no contest to Count one, the only charge, driving under the influence of alcohol, class B, non-person misdemeanor.
Mr. Kellogg, how do you plead to driving under the influence of alcohol or drugs?
No contest, Your Honor.
By pleading no contest, do you mean you're not admitting the charge, but you're not going to deny it and take it to trial?
Yes, Your Honor.
You understand you'll still be found guilty and unable to appeal your conviction?
Yes, Your Honor.
Anyone making you enter this plea today?
No, Your Honor.
All right, Mr. Regier, have you a factual basis for this charge?
Yes, Your Honor. Paragraph 4 of the affidavit does appear to refer to an encounter occurring on June 22nd, 2024. Forgive me.
Someone needs to mute.
The encounter appears to involve a vehicle traveling westbound on K254 at mile marker 22. State's understanding is that is within Butler County, Kansas, specifically between Towanda and El Dorado city limits, which the state respectfully submits would give this court jurisdiction. It would appear that upon observing signs of impairment, the officer conducted standard field sobriety testing. Subsequently, it would appear that blood alcohol concentration was measured in excess of the legal limit, specifically 0.147, according to paragraph 17 of the affidavit.
I find the defendant has knowingly and voluntarily entered a no contest plea and the state has provided the factual basis. I find the defendant guilty. I would proceed to sentencing. We do have an alcohol and drug evaluation by Assessor Nancy Chavez. Recommendations being that the defendant complete a 48-hour alcohol substance abuse program and abstain from alcohol. Mr. Regier, recommendations.
One moment, Your Honor. Forgive me, Your Honor. The state is recommending at this time, pursuant to plea negotiations, the statutory minimum fine for a Class B DUI of $750. Court cost that the court make a determination on the issue of attorney's fees. The state is further recommending that the court impose an underlying sentence of 6 months, the maximum for a Class B misdemeanor, subject to a year of reporting probation, subject to all standard conditions, including a $6 probation fee, that the defendant be ordered to complete a DUI victim panel, comply with all recommendations of the drug and alcohol evaluation, and any other orders the court may deem appropriate.
Mr. Patterson?
Judge, I am retained in this case. Nothing further.
Very well. At this time, Mr. Kellogg, I will sentence you to 6 months in the county jail and order a fine of $750. I will also assess 108 court costs, $60 supervision fee, and your probation will be for 1 year. Your probation will include all standard conditions and special conditions, the DUI victim panel, completion of the alcohol and substance abuse program, 48-hour program, and that you sign all releases between court services and any other entities that need to be signed in order to give probation access into conditions of probation. You will need to pay at the rate of 1/12 per month, at least 1/12. Each payment will be due on the 19th of the month, with the first one being due June 19th, 2025. Any questions about this, Mr. Kellogg?
No, Your Honor. I'm not sure if it matters, but I was going eastbound. They said I was going westbound on 254.
Okay.
I don't know if
Okay.
that matters. I just...
Is it still within our jurisdiction, Mr. Regier, I trust?
Yes, ma'am.
That would be the state's evidence for this case to proceed to trial, Your Honor.
Thank you. All right. Call your probation officer immediately, 316-322-4153. If they're at lunch, leave a message and call again today until you get them. Mr. Regier or Mr. Patterson, anything further?
Nothing further, Judge.
Mr. Regier, anything further?
If court is not making any orders about the manner in which this case is to be repaid in full, the state has nothing further, Your Honor.
I believe I said 1/12 for a month, first payment due June 19th and on the 19th of each month thereafter.
Very good, Your Honor.
Thank you. You may go call your probation officer, Mr. Kellogg. Will now be on the record in BU 2024 TR 1197, State of Kansas versus Jason Paul Leach, Jared Regier for the state, Darren Patterson for the defendant. Mr. Leach.
I have not seen him on here. I would tell the court that we have been attempting to contact him, but have been unsuccessful. I have no explanation of why he's not here today.
The court does issue a bond forfeiture, a bench warrant, and no bond hold. We will now be on the record in Lawless, case number 2024 TR 2098, State of Kansas versus George Leonard Lawless, Jared Regier for the state, Darren Patterson for the defendant, who also appears in person. Mr. Regier, Mr. Patterson, I guess Mr. Patterson, it's back to you.
Judge, this is a case where I need about 2 minutes in a breakout room with Mr. Lawless, and then I believe it's going to be for plea.
Very well. Jen, if you'd please put Mr. Lawless and Mr. Patterson in a breakout room. Mr. Lawless, look for that invitation on your screen.
Yes, ma'am.
And then Regier.
That is the state's contemplated amendment as the state understands the terms of the plea negotiation reached between counsel for the defense and my office, Your Honor.
And to clarify, that is tampering with an ignition interlock device, circumventing it, or rendering it inaccurate or inoperative, Mr. Patterson?
Yes, Your Honor.
Mr. Regier?
I believe that is an accurate quotation of subsection A1 of KSA 81017, Your Honor.
All right. And how does your client intend to plead again, Mr. Patterson?
Guilty, Your Honor.
Mr. Lawless, how do you plead then to speeding 106 miles per hour in a 75 mile per hour zone?
I plead guilty.
And how do you plead to the amended charge of KSA 8-1017, parenthesis little a, close parent, parenthesis 4, close parent, which, I'm sorry, 1, which is to tamper with an ignition interlock device, circumventing it, or rendering it inaccurate or inoperative?
I plead guilty.
By pleading guilty, you're admitting these two charges, that you did speed at 106 and that you did in some way tamper with your ignition interlock?
Yes, ma'am.
All right. And did this happen in Butler County, Kansas, on the Kansas Turnpike, commonly known as, or officially known as I-35, at mile marker 86 South?
Yes, ma'am.
On August 9th of 2024, was that the right day this happened?
Yes, ma'am. I believe so.
And the speed zone there is 75. I can take judicial notice of that, but do you agree it was that speed on that day? That was the speed
Yes,
limit.
ma'am. Yes, ma'am.
Is anyone making you enter this plea today by any threats or promises other than your plea agreement?
No, ma'am.
And you understand you're giving up your right to a trial? You'll be found guilty and unable to appeal your conviction?
Yes, ma'am.
And I do find that you freely and voluntarily entered your pleas today. and that you have provided a factual basis to support them. So I do find you guilty of the charges 1 and 2. Mr. Regier, have you any recommendations for sentencing?
Yes, Your Honor. Pursuant to plea negotiations for the Sweden, the state is prepared to recommend the scheduled fine and court costs, as well as for the court to make a determination on the issue of attorney's fees if counsel for the defense is appointed in this case. For count 2, the circumvention of ignition airlock charge, the state would be recommending a $100 fine, subject to 120 days underlying sentence and a year of non-reporting probation.
Mr. Patterson, anything further?
Judge, I am retained on this case. Nothing further.
Mr. Lawless, at this time, on count 1, your fine is $108. On count 2, I'm sorry, strike that. Your fine on count 1 is $210. That's the scheduled fine. On count 2, your fine is $100. You're also assessed $108 court costs. Your sentence will be 120 days suspended so long as you successfully complete a 1-year non-reporting probation. You don't have to see a probation officer, but you do have to follow the probation orders I'm about to give you. 1, you are to violate no laws of any kind during this 1 year. 2, you're to pay the total of $418. Can you, oh, wait a minute, maybe that's, no, that's right. Can you pay that within 60 days, or do you need a little more time?
60 days, ma'am.
And pay that within 60 days, don't violate any laws, and you will have satisfied this probation at the end of 1 year. If you
Yes,
want
ma'am.
to know how to pay that online or any other way to pay it, please call the clerk of the district court in Butler County at 316-322-4370. 4370.
Ma'am, the number broke up. I didn't get, all I got was 322.
All right. Call the Butler County Clerk of the District Court at 316-322-4370.
Last number.
0
70.
4370.
70. Okay. That's
Correct.
322-4370.
That is correct, yes. Anything
Hello?
else from anyone?
Not on this matter, Judge.
Okay, if there's nothing else, Mr. Lawless, you are excused from today's proceedings.
Thank you.
You are welcome.
Bye-bye.
Bye-bye. We'll now be on the record in 2024, BU 2024, CR 503, State of Kansas versus John Marshall Shoemaker. Jack Regier for the state. Is John Marshall Shoemaker here?
Yes, I'm here.
The gentleman marked John McGee, M-A-G-E-E. You are also John Marshall Shoemaker.
Yes, ma'am.
The defendant appears in person and with counsel Darren Patterson. Mr. Patterson?
Judge, this is a case that will end up going to trial. I can tell the court that I had originally discussed with the county attorney's office that I would be requesting a continuance because I'm missing some witnesses. To explain that a little bit further, there are two eyewitnesses that were not subpoenaed by the state. I have now contacted and have clarification on one of them that they can be there on Wednesday and be prepared to testify. The other one, though, did have a child. The birth was last Thursday, and I'm a little bit tentative on knowing how to press somebody who's just given birth to be at court. So I have to continue with what I originally had requested, or that I told the prosecutor I'd request, which was a continuance to the next court date, so I can make sure and have both eyewitnesses, and these are actual eyewitnesses, Your Honor, present to testify.
All right, well, before I grant a continuance, this may be the case that needs to go. I'm going to withhold ruling on the request for continuance and have Mr. Shoemaker McGay stay with us for a bit till we get to the end of the docket.
Yes, sir.
So we'll be in recess. We'll now be on the record in 2024 TR 234, State of Kansas versus Daniel Moriarty. Jared Regier for the state, Darren Patterson for the defendant, Daniel Moriarty, who also appears in person. If you'd start your audio and video, thank you, sir. Mr. Patterson.
Thank you, Judge. When announced this time pursuant to plea negotiation, the state has agreed to amend the charge to that of KSA 8235, no valid driver's license. To that amended charge, Mr. Moriarty will enter plea of guilty.
And do you so amend, Mr. Regier?
The state would so amend, Your Honor.
Very well. Mr. Moriarty, how do you plead to the amended charge of driving without a license in Butler County, Kansas on October 25th of 2023?
Guilty, Your Honor.
By pleading guilty, you're admitting that you drove without a license in Butler County on that day?
Yes, Your Honor.
And did you do that driving on Wednesday, October 25th of 23, as the officer alleges?
Yes, Your Honor.
And were you on Highway 54 at Southwest Santa Fe Loop Road, Augusta, Kansas, in Butler County?
That's correct, Your Honor.
And you didn't have a driver's license?
That's correct, Your Honor.
Anyone making you enter this plea today by any threats or promises other than your plea agreement?
No, Your Honor.
You understand you're giving up your right to trial, including the jury trial we're set for, and that you'll be found guilty and unable to appeal your conviction?
I do, Your Honor.
All right, I accept your plea as freely and knowingly given, and a factual basis exists to support it. Finding the defendant guilty, I would inquire of sentencing recommendations, Mr. Regier.
Yes, Your Honor. Pursuant to plea negotiations, the state is recommending a $100 fine, that the court make a determination on the appropriate amount of court costs, as well as a $60 probation fee. The state is further recommending that the court make an appropriate determination on the issue of attorney's fees, as well as impose a 12-month reporting probationary period subject to a 6-month underlying sentence, the maximum sentence allowed by law for a Class B misdemeanor.
Mr. Patterson, anything further?
Nothing further, Judge.
Mr. Moriarty, where do you work?
I work at DHL Logistics for Case New Holland.
Okay. At this time, I am ordering you to pay a fine of $100, also assessing $250.
And Judge, I'm sorry, I'm retained in this case.
Oh, you're retained. Okay. You did say that. I am ordering a fine of $100 and assessing 108 court costs and $60 probation supervision fee. Your sentence will be for 6 months. That will be suspended so long as you comply with your 12-month non-reporting probation. You have but two conditions of probation. One, violate no laws during this 12 months and pay the total of $268. Can you do that within 30 days, sir?
I will have you guys paid on Friday.
And
Very
Your Honor,
well.
and Your Honor,
Mr. Regier?
forgive my interjection. If the court is assessing a $6 probation fee, is that a 12-month reporting probation? That was the state's understanding of the plea deal negotiated in this matter.
You're recommending reporting probation, Mr. Regier?
That was contemplated by the plea agreement reached between the state and the defense, as I understand it, Your Honor.
All right. Well, I will follow the plea agreement, so you will have to report as directed. Contact probation at 316-322-4153. Call them as soon as this hearing is over. And if you don't get them, leave a number and call after lunch. But again, it is $100 fines, 100 court costs, $60 supervision fee. It is a 6-month sentence. It is still suspended, but you will have to report to probation as directed. Anything further?
Judge, the only additional item is that talking with Mr. Moriarty this morning, he was concerned about making sure probation knew that he had a pre-planned trip already to Texas in July, I believe it was. I told him as long as he speaks with his probation officer about that, there shouldn't be a problem with that. I just wanted to bring it up since Mr. Moriarty was concerned about it.
The court is granting you permission, Mr. Moriarty, to take that trip, but you do need to get it approved by court services before
Certainly,
you
Your
go.
Honor.
All right.
Certainly.
All right. Nothing further. You are excused at this time, sir.
Thank you, Your Honor.
You're welcome. We'll now be on the record in PAPS, that is BU 2024 CR 431, State of Kansas versus Michael Lynn Papps, Jared Regier for the state, Darren Patterson for the defendant. Michael Papps, who also appears in person. Mr. Papps, start your audio and video, please. Thank you, Mr. Papps. Mr. Regier, I'm sorry, Mr. Patterson.
Your Honor, pursuant to negotiations, I would announce this time, Mr. Papps will be entering a plea of no contest to count 1, possession of marijuana. States agreed to dismiss count 2, possession of drug paraphernalia.
That is your agreement, Mr. Regier?
That is the state's understanding, Your Honor.
How do you plead, Mr. Papps, to count 1, possession of marijuana?
No contest.
By pleading no contest, you're not admitting the charge, but you don't want to deny it and take it to trial either?
Correct.
Anyone making you enter this plea today by any threats or promises other than the plea agreement?
No, ma'am.
And you understand with this plea, you're giving up your right to trial and will be found guilty and cannot appeal your conviction.
Yes, ma'am.
Very well, Mr. Regier, factual basis.
Yes, Your Honor. Pursuant to the amended affidavit in this case, paragraph 4 appears to refer to an encounter occurring on May 1st, 2024 in the 19,000 block of Southwest Butler Road, Butler County, Kansas, involving a 2008 Toyota Camry. It would appear that a traffic stop was conducted by law enforcement the defendant was located as an individual occupying the vehicle. Subsequently, pursuant to paragraph 12, it would appear that law enforcement conducted a search of the defendant, and inside the defendant's right front pocket, law enforcement discovered a vape cartridge containing a fluid consistent with THC juice, which was later subject to field testing. That's quoting directly from paragraph 12 of the affidavit.
And field testing confirmed the presence of marijuana.
Your Honor, were this case to proceed to trial, the state's evidence would show the same.
Very well. Count 2 is dismissed. The defendant is found guilty of count 1, possession of marijuana. Mr. Regier, recommendations for sentencing.
Yes, Your Honor. At this time, the state is not recommending a fine. However, the state is recommending the imposition of court costs and a probation fee, and for the court to determine attorney fees. The state is further recommending on the sole count remaining before the court an underlying sentence of 120 days, subject to a 6 months reporting probation, and that the defendant be ordered to complete a drug and alcohol evaluation and follow all recommendations. I further do not know whether or not this final issue was discussed during the context of plea negotiations. However, this does appear to be a case where KBI restitution applies.
Anything further, Mr. Patterson?
Judge, I am court appointed in this case. I would tell the court I am aware of the KBI report that the drugs were further tested and acknowledge that there is a fee for that. Nothing further.
Thank you. Mr. Paps, where do you work?
I'm currently unemployed.
When did you last work?
It was about 2 months ago.
And what did you do at that time? What kind of work?
I was working for a construction company called Savvy Builders.
And why do you no longer have that employment?
Due to attendance.
Attendance?
Yes,
Are
ma'am.
you looking for work? Are you planning to have work in the near future?
I just need to get transportation and I can get that job back.
And who's supporting you these past 2 months?
My wife.
At this time, you are ordered to pay the KBI $400. There will be no fine. There will be $158 court costs. There will be $60 probation supervision, and I am imposing $250 attorney fees because I believe you can work. You just need to do so. I will grant you a 6-month controlling sentence that will be suspended, provided you I'm sorry, I strike that. I am giving you a 120-day jail sentence that will be suspended, provided you successfully complete reporting probation. Mr. Regier, was the plea agreement that be for 6 months?
That is the state's understanding, Your Honor.
Ma'am,
Yes.
sorry. I just wanted to let it be known that I currently live in Wichita. That transportation would be really hard for me to get back and forth.
Well, the alternative is to have you serve the 120 days in jail. You want to do that?
I mean, I'd rather not. I'll try my hardest to get there. I mean, I'll have to reach out to some, like my mom and whatnot, but.
Well, how do you get to work? Oh, you said you got to get someone to take you?
Right.
I'm going to make this a 12-month reporting probation because I just don't foresee you getting everything done in 6 months. I am ordering that you find employment and maintain it. I am ordering all other standard conditions. You are ordered to get a drug and alcohol evaluation and comply with it. You are to call and schedule that evaluation within the next 14 days. You are to pay a 12th of the amount owed, which includes $400 KBI, 158 $158 court fees, $60 probation supervision fee, and $250 attorney fees. Pay the rate of 1/12 per month, 1/12 due on the 19th of each month. First payment due June 19th, 2023. Call the probation office immediately after court. Are you ready to write it down?
Yeah. Go ahead.
I'm just curious, did you hear me tell everyone to get a pencil and paper a while ago?
My wife has her phone. She has it right now.
So you did hear me?
Yes, ma'am.
All right. Call the probation department at 316-320-4153.
Yes, ma'am.
Call them immediately after court. If they don't take your call the first time, leave a message. Call them later in the day to make sure you get through. Make sure
Okay.
also that you have that appointment for alcohol and drugs scheduled within the next 14 days. Make sure you follow all of its conditions. Sign any releases necessary for the evaluator and treatment provider to correspond with your probation officer.
Okay.
Mr. Aguirre, anything further?
Not on this matter, Judge.
Mr. Patterson, anything further?
Nothing further, Judge.
Mr. Paps, anything further?
No, ma'am.
Thank you. Then you are excused at this time, Mr. Paps. You may go. We will now be on the record in 2024 CR 388, State of Kansas versus Justin Lee Thorburn. County Attorney Jared Regier for the state, Attorney Darren Patterson for the defendant, Justin Lee Thorburn, who appears in person. Mr. Patterson.
Your Honor, after further discussions with Mr. Sweeney, there was a agreement that this case would be dismissed with prejudice because it was part of a previous global plea bargain on some felony cases that my client's currently on probation for.
And as a representative of the state, you support that and so move, Mr. Patterson? For Mr. Regier?
One moment, Your Honor. I am in the process of confirming that if the court will allow it.
Certainly. Go ahead, please.
That would appear accurate. Unfortunately, I'm not in a position to advise the court as to which specific cases.
Very well. Mr. Thorburn, at this time, you are excused. The parties will journalize, if they have not already done so, your dismissal with prejudice. Thank you.
Thank you.
You're welcome. We will now be on the record in Tullis, BU 2023 TR 3074, State of Kansas versus Lucas Tullis. Jared Regier for the state, Darren Patterson for the defendant, who also appears in person. Mr. Patterson, announcements?
Thank you, Judge. I would announce this time Mr. Tullis is going to enter a plea of guilty to the charge of driving after being declared a habitual violator.
Mr. Tullis, how do you plead to count one, driving after being declared an habitual violator? How do you plead? I'm sorry, sir, I didn't hear you. We're having a hard time. You're not putting out any sound.
He spoke to me earlier, Judge, so not for sure what's happened. There, say it again, Mr. Tullis, say this.
Can you hear me now?
Yes.
I plead guilty.
By pleading guilty, you're admitting that you did drive in Butler County, Kansas on July 30th of 2023 at a time while your driver's license was revoked due to habitual violator status?
Yes, ma'am.
And are you pleading guilty because you believe you were in fact guilty?
I am guilty, yeah.
And you understand you're giving up your right to trial, including the jury trial we have reserved for you with this plea?
Yes, ma'am, I do.
And do you understand that you'll be found guilty and won't be able to appeal that conviction?
Yes, I do.
And is anybody making you do this today?
No, Your Honor.
Did this happen, as the officer's affidavit alleges, out on Highway 54 outside of Augusta, approximately 7:40 a.m.?
Yeah, that is correct.
All right. I find that your plea is freely and knowingly given with a factual basis. Oh, and your license had been declared habitual, you said, right?
Yes, ma'am.
Prior thereto. All right, I find you guilty. Recommendations for sentencing, Mr. Regier.
Yes, Your Honor. The state's understanding is this is a case where the elevated sentence under KSA 287 applies. Therefore, pursuant to plea negotiations, the state is recommending the minimum fine required by law of $1,500. Also, pursuant to plea negotiations, the state is recommending court costs and a probation fee of $60, and for the court to make a determination on the issue of attorney's fees. The state is further recommending an underlying sentence of 1 year, subject to 1 year reporting probation. The state is not opposed to any orders the court may make as far as courtesy supervision is concerned, also pursuant to plea negotiations. The state's understanding is that pursuant to KSA 287, quote, the person convicted shall not be eligible for release on probation, suspension, or reduction of sentence or parole until the defendant has served at least 90 days imprisonment. The 90 days imprisonment mandated by the section may be served in a work release program only after such person has served 48 consecutive hours imprisonment, provided such work release program requires such person to return to the confinement at the end of the work release program. The state is prepared to recommend that the court follow the statute insofar as 48 consecutive hours and any other orders the court may deem appropriate insofar as the 90 days are concerned.
Well, we don't have a work release program here, do we?
Judge, the statute also allows house arrest program, and that is part of the agreement.
Does it actually allow it, or it's just silent on house arrest?
Your Honor, pursuant to at the very conclusion of KSA 287, it does appear to provide, quote, the court may place the person convicted under a house arrest program pursuant to KSA 216609 and amendments thereto, or any municipal ordinance to serve the remainder of the minimum sentence only after such person has served 48 consecutive hours imprisonment.
Okay. All right, at this time, Mr. Tullis, you live in what area, what town, city, state?
North of Emporia, Lyon County.
Lyon County, okay. Where do you work?
Simmons Pet Food.
And Your Honor, if the court wanted further information, I did send an email to court and counsel this morning with some additional documents. Those documents included a letter from his community corrections officer that outlines the things that he's currently involved in, which includes drug court, which includes that he is a part of the Corner House alumni group where he has already completed his drug and alcohol treatment completely. He is employed. My client also provided the drug court meeting criteria they go through, as well as some of his other meetings he has, and the breakdown of his monthly costs, which includes Butler and Associates taking $1,100 out of his paychecks, which is why he basically works a second job because of how much he's paying there. But those are additional documents for disposition in the case, Judge.
Very well. At this time, Mr. Tullis, you are fined $1,500 and ordered to serve a 1-year sentence. You also have attorney fees of $250, court costs of $108, and supervision fees of $60 because I am granting you a 1-year reporting probation after you've served 90 days. I don't want you to lose the job you have, so I will let you serve that 48 hours in jail, followed immediately by the remainder in house arrest, and only allowed to leave the house for work release. And to go directly to work and directly home. You're allowed to have courtesy supervision in your home county if that can be arranged. You are to pay 1/12 of the total due each month. On the 19th day of each month, your first 1/12 payment is due on June 19th of 2025. You are to start serving the 90 days within 1 week. When do you want to check in?
So it was my understanding that I was going to need to be put on house arrest before going into jail, or is that something that I can do upon immediate release if I had that set up?
What I'm envisioning is you serve the 48 hours, but before you go in, you contact the ankle monitor, electronic monitoring people so that they will show up when you get out of jail.
Okay.
And you'll go immediately onto that and immediately home.
Okay. Can we do that Monday? I guess that's Memorial Day.
And he's thinking of his days off from work, Your Honor. He's not a weekend person. He's a weekday is his off days. That's why he's asking for Monday.
You can begin that Monday, May, I believe that's the 26th. At what time are you checking in? 7 a.m.?
I'll be there. Yeah, 10 a.m. works great.
10 a.m. You must be there with the photo ID out there at 701 Stone Road. And like I said, call your EMD, electronic monitoring, and have them ready to show up when you get out.
I can do that. My only question is, so I am on felony corrections here in Lyon County, part of a drug court program. And I do have to go to court once a month. I have to go to an alumni group for drug and alcohol treatment once a month. And I have to attend 3 meetings a week. That's NA, church, AA.
I will authorize court appointments and treatment appointments.
Okay. Yeah, I just wanted to specify that. Okay.
Thank you for inquiring. Anything else?
I need to call probation right away, or?
Yes, call them right after court at 316 322 4153.
4153.
And Mr. Patterson, do you have the EMD number for him?
Yes. Write down this phone number also and call them after probation. 316 322 0021.
0021.
Correct.
Okay, I will call both of them right now.
All right, Mr. Patterson, anything further?
Nothing further.
Mr. Regier,
One moment, Your Honor.
while you're taking a moment, Deputy.
Judge, what was the charge on that?
His charge was driving after being declared habitual violator.
Okay, sounds good. Thank you.
Thank you.
Nothing further from the state, Your Honor.
All right, then we are in recess. Mr. Tullis is excused to call probation.
Thank you so much.
You're welcome. We'll now be on the record in Warren, case number BU 2024 TR 1832, State of Kansas versus Joel Patrick Warren II. Jared Regier for the state, Darren Patterson for the defendant, who also appears in person. Mr. Patterson.
Judge, pursuant to plea negotiations, I would announce at this time, Mr. Warren will be entering a plea of guilty to count 3. No proof of insurance. States agreed to dismiss 1 and 2.
Mr. Regier, that's your agreement?
That is the state's understanding, Your Honor.
Mr. Warren, that's your agreement?
Yes, ma'am.
How do you plead then to count 3, driving in Butler County, Kansas on July 8th of 2024 without liability insurance or proof of liability insurance?
Guilty.
By guilty, you're admitting that you did drive without insurance?
Yes, ma'am.
Is anyone making you enter this plea today by any threats or promises other than your plea agreement?
No, ma'am.
You understand that you will be found guilty having given up your right to trial and you'll not be able to appeal your conviction with this plea.
Yes, ma'am.
And where were you driving in Butler County without insurance when the officer stopped you?
On the turnpike?
I-35, Kansas Turnpike.
Yes, ma'am.
And if the officer said you were doing so at mile marker 57 north in Butler County, you'd agree with that?
Yes, ma'am.
All right, I will accept your plea as knowingly and voluntarily made, find you guilty. Recommendations, counsel?
Yes, Your Honor. Pursuant to plea negotiations, the state is recommending the minimum fine required by law of $300, as well as the imposition of court costs. State is further recommending a 6-month non-reporting probationary period subject to an underlying sentence of 120 days.
Mr. Patterson?
I am retained in this case, Your Honor. Nothing further.
Okay. Mr. Warren, where do you work?
Dillon's in El Dorado.
Full time?
It's part-time right now, but I'm gonna be looking for some full-time employment.
And Judge, I'm retained in this case.
Oh, I thank you. All right, at this time, you are fined $300 and assessed court costs of $108. You're given a sentence of 120 days, but that is suspended so long as you successfully complete 6 months non-reporting probation. The non-reporting probation has 2 conditions. 1, do not violate any laws during the next 6 months. 2, pay the 408. Can you do that within 30 days?
Can I have 60 days?
You can have 60 days.
Okay.
Is that going to be enough?
Yes.
All right, I'm going to order that you pay the 408 within 60 days. As long as you pay within 60 and violate no laws, you'll be in compliance with your probation. Anything further, Mr. Regier?
Not on this matter, Judge.
Mr. Patterson?
Nothing further.
Then we all are in recess and Mr. Warren is excused. Oh, and for the record, the other counts are dismissed on motion of the state. Appropriately. Thank you. You may go, sir.
Thanks.
You're welcome. We'll now be on the record in 3 cases. BU 2024 CR 288, BU 2024 CR 291, BU 2024 CR 374, each captioned either State of Kansas versus James R. Young or State of Kansas versus James Richard Young. Jared Regier for the state, Darren Patterson for the defendant, who appears in person on all 3 counts or cases. Mr. Regier or Mr. Patterson?
Your Honor, these are announced for trial.
These are for trial. Can we consolidate these? Any reason we can't?
I apologize. I didn't understand the court.
Any reason why we couldn't consolidate these?
I would object to consolidation. Yes, Judge. I think the facts are pretty different from one another, as well as there's one that they have different victims, so that there's no motion on file to consolidate.
All right. Well, court on its own motion brought it up. Okay. Count in 24 CR 288. The defendant is alleged of violating a protection order. Who the contact was with? Is it alleged to be Elizabeth Goucher also?
Yes, Judge.
(24 CR 374), domestic battery. And that allegedly occurred August 2nd of 24. After the 2 violations. With Tricia Williams. All right, I see where the Tricia Williams would be different. How about the two cases with the same victims, the two protective orders?
Judge, I am not prepared to take that up. It's not before me. I haven't received a motion for it. I haven't researched it. Right now,
Oh.
they're two separate cases, so I guess I object to it coming up right now.
All right, which of those three do you prefer to take up? They all happen within a couple months of each other.
James Young's phone died. He's running into the courthouse right now.
Hmm?
James Young.
Okay, James Young's phone died. He's running into the courthouse right now. All right, we'll give him a minute.
I was right in the middle of my Zoom court, so I need to go down to the side. My phone overheated.
And Judge, my client's relocating to the courthouse. He's having phone issues.
Okay, Judge.
All right,
Sorry, Your Honor, my phone overheated right at that moment.
well, I'm just glad you're at the courthouse so we could proceed. We are continuing with the three cases concerning James Young. So the defense counsel has made it abundantly clear that they object to consolidation as the court had considered. The case of law.
I believe so, Your Honor. If you want to put Mr. Plano in a breakout room, we can visit briefly, but I don't believe we'll get a big resolution. But I don't mind talking.
All right, I'd like for you two to go to a breakout room, but before you do, Miss Gillette, are there any announcements on the Chase Miller's case? The
Yes.
one that can.
Yes, Your Honor. If
All
you'd
right.
like me to speak.
All right, we'll be in recess on Hunt. We'll go on the record in 24 CR 12, State of Kansas versus Chad Cooper, County Attorney Jill Gillette for the state, Attorney Chase Miller for the defendant, who also appears in person. Mr. Miller, any announcements on that?
Yes, Your Honor. May it please the court. We have tentatively resolved this case by a diversion. That application has been submitted and we're waiting on review. So
When did you submit that application?
this morning.
This morning. Okay. So we can put that maybe on a misdemeanor control docket, and if it's diverted, it'll go off docket. If it's not diverted, maybe what? Okay. So is Missy with us? Miss Gillette, when's our next available misdemeanor docket that you?
I'm here, Judge.
Okay, you are. Missy, we need a misdemeanor control docket for Chad Cooper.
Do you want to go out about a month?
Is that enough time, counsel parties?
I believe so.
Yes.
Okay. How about June 24th at 3:30?
June 24th, 3:30.
I can make that work.
Okay. Now, if that is not diverted, will that be for plea, or are you going to continue that for jury trial, Mr. Miller?
Well, I think I'd have to unfortunately discuss that further with my client, but we'd certainly have that answer ready at that time if it comes to it.
Very good. All right. If there's nothing further, then we will be in recess on Cooper with Mr. Cooper continuing on your bond. Mr. Cooper, you're going to have the same conditions with the added condition that you reappear June 24th at 3:30 if your attorney does not tell you otherwise. Can you unmute and indicate that you are following us? Click that little red icon that looks like a microphone if you have it.
While he sorts that, Your Honor, do we have Zoom authorization for that future date?
Absolutely, yes. Thank you for asking and clarifying that.
Thank you.
Mr. Cooper, if you're hearing me, give me a thumbs up. He shut off his video. Okay,
we go.
All right. Thank you. I see a thumbs up. You're excused at this time, Mr. Cooper. Mr. Miller, you're excused as well.
Thank you.
You're welcome. And now we're going into a recess on Hunt and Missy. Who's running my Zoom today? Is that Jen that's running the Zoom?
Yes, Your Honor.
And Jen, if you would please put Miss Gillette and Mr. Paul in a breakout room for another ditch effort of trying to resolve this. And if you want to revisit Turner, that'd be perfectly agreeable too. Thank you. Are there any on the Butler County docket that are definitely for plea or dismissal?
Your Honor, any it appears with Philip Moore, ours will be for a plea for a second offense DUI.
That's, you said the defendant is Burrows?
Philip Moore.
Oh, Philip Moore, I'm sorry. All right. Anyone else?
Your Honor, the Tyson Arnold case,
Yes.
a journal entry of dismissal was filed minutes ago.
Mr. Regier, that's correct. Mr. Regier?
One moment, Your Honor.
That's correct, Your Honor.
That would appear accurate, Your Honor.
All right, thank you. All right, who's at the Butler County Detention Facility? I'm sorry, sir, you're muted.
Your Honor, we have Mr. Hughes and Mr. Nelson here at the jail.
And are they both Mr. Patterson's clients?
I believe so, Your Honor.
Mr. Patterson, is he available or is he in a breakout room?
He is currently in a breakout room.
Deputy at the jail, has he talked to his clients lately? Do you know?
Not that I'm aware of, Your Honor.
All right, well, let's see if we can get that done in the near future, like within the next few minutes. Okay, we have back, Miss Gillette, did you get to go in the breakout room? Okay. Jen, we needed Miss Gillette in a breakout room with Mr. Paw. Okay, there we go. It looks like maybe. Yeah. All right, so let's go on the record in Arnold. So we can let a couple of people go on Arnold. We're on the record in 2024 CR 369, State of Kansas versus Tyson Keith Arnold. Please announce appearances.
Jerry Regier on behalf of the state.
Gail Jensen for Tyson Arnold.
That's not Tyson Arnold behind you, is it?
No, this is Mr. Martinez. That's the only other case I've got. Mr. Arnold's not here because Judge Rickey announced the dismissal from the bench back in April when a plea was done that disposed of this case along with another one that was pending before him on his pretrial docket.
I see. And Mr. Regier, is it correct that that journal entry has today been filed to dismiss this case officially?
Your Honor, that is what the state's notes would appear to reflect, Your Honor.
All right, so that was dismissed with prejudice per plea agreement in Judge Rickey's felony case.
And Your Honor, for the court's edification, what I would tell the court is there does appear to be another Butler County case 24 CR 424. It would appear that that matter was previously set for pretrial on April 1st before Chief Judge Rickey, at which time the case did proceed to disposition.
Oh, very well. Then Arnold is officially dismissed in 24 CR 369, and the defendant is excused if he is here. His attorney would be, but you said you have Mr. Martinez with you, Mr. Jensen?
Yes, Your Honor, I do. It's 24 CR 013.
We'll be on the record in 2024 CR 13, State of Kansas versus Luis Angel Martinez. please announce appearances.
Jerry Regier on behalf of the state.
Gail Jensen for Mr. Martinez, who appears seated to my right in my office and connected to the court by Zoom.
All right, and do we have any announcements on that, gentlemen? Any?
Your Honor, this is much like the court heard earlier. I don't believe I'm in a position to where we could accept a plea offer. I'm also a little uncertain as to how the state would intend to proceed. It appears from reviewing the court file that an essential witness, specifically Officer Blake Weekly of the Rose Hill Police Department, was not served with a subpoena, and the message on the return of service said no longer with department, no FW, which I think meant forward. And I see no evidence of service on Michelle Martinez either. So I don't know how we would proceed, although the case from our perspective remains for trial.
This case is over a year old. It allegedly occurred, the crime of domestic battery allegedly occurred January 6, 2024. Mr. Regier, do you have witnesses ready to go Wednesday?
Your Honor, I believe that, Your Honor, the state would request a recess to review this matter further. I believe there are other prosecutors from my office who may be in a position to take up other matters, but I will need the opportunity to review this matter briefly.
Very well. And then I want, if depending on the outcome of that, we may need to have you go in a breakout room with Mr. Jensen. But we'll take a brief recess in Martinez, and then if we, well, we'll just leave it at that. Mr. Stang, do you want to take up one of your cases now, or do we need Mr. Regier for that?
Your Honor, I'm available, assuming that we're taking up Hoos.
That's the only one I think I have this morning, I hope.
Okay.
Let's take that up then. We are on the record in 2022, TR 3507, State of Kansas versus Timothy Edward Hoos. Brett Sweeney for the state, John Stang for the defendant, who also appears in person. Gentlemen, are there any agreements on this case?
Your Honor, if I may,
Yes.
This is a case that Mr. Stang and I have been having communication on for months and months. At this time, the state's going to go ahead and dismiss this case without prejudice. The court's aware DUIs can't be dismissed without, some evidentiary issues. And I think that's the case here, at least as it stands right now. So the state would go ahead and cite those evidentiary issues as a reason for dismissal without prejudice of this case. Of course, it can be refiled if need be.
Your Honor, I agree
Okay.
with the
Go ahead,
evidence.
Mr. I'm sorry, Mr. Stang, I kept cutting you off. Go ahead, please.
I would agree with the evidentiary issues. There's some insufficient evidence in this case. So I would agree with Mr. Sweeney's stance.
Well, this
And no objection.
this third time DUI allegedly occurred September 23rd of 2022, and we've had a number of years of the parties wrangling it around, looking at the evidence, and if you conclude that there is insufficient evidence, I think a dismissal would be appropriate at this time. I will grant that, as counsel said, without prejudice, where it could be refiled if appropriate. So Mr. Hoos and his counsel, Mr. Stang, are excused at this time. Thank you, counsel.
Thank you, Your Honor.
You're welcome. Let's see. Mr. Jensen, did you get the breakout room with Mr. Regier yet? No? You're muted, sir.
Your Honor, I haven't got an assignment yet. I think he was the one who wanted to go check
Right.
with other counsel and
Okay.
check the court file. I don't know that he really needed to speak to me so much.
All right. Well, we have Ms. Gillette and Mr. Paw back on our Greenwood County. We are back on the record in Greenwood County 2024 CR 235 State versus Heather, I'm sorry, TR 2024 TR 235 State versus Heather Hunt. Parties as before. Ms. Gillette, Mr. Paw, any successful negotiations or announcements?
Judge, after speaking with Ms. Gillette, we both think we cannot try this in one day. We think it's going to take longer. What we had talked about is, Judge, is maybe special setting this for July 22nd. That's a Tuesday. That's a Greenwood County docket day, and there's nothing on my calendar for that day.
Missy, does it look like we could do that? If we, of course, we'll have to get authority of
For a bench trial? Jury trial.
Jury trial.
We'd have to get special authorization from Chief Judge Ricky to do that. I don't, there's a lot involved, as you all know, with getting jurors summons.
We understand that, Judge. We're trying to be accommodating.
And we do need to do what we need to do. So, Missy, let's tentatively put that at that point. And if it doesn't work, then we'll all get back together and.
July 22nd?
9 a.m., yes.
Okay, that's a Tuesday, so we'd have to break for first appearances at 1:30.
Unless we could get someone else to cover those. You are absolutely right. All right, so we have Michelle Turner as Greenwood Prime this Wednesday at 9 and 23 TR 807, and we have Heather Hunt Jury Trial Prime July 22nd at 9 a.m. contingent upon authorization. So, Ms. Hunt?
Yes, ma'am.
I'm going to continue your case to that date, July 22nd at 9 a.m., which means, of course, you will be continued on your bond with all continuing conditions.
Yes, ma'am.
Thank you. You are excused at this time. And
you're expressly no contact with the victims until trial.
No contact with the victims.
I have not had any contact with them.
All right. Thank you, Ms. Hunt. You are excused. I believe we've already excused Ms. Turner. Mr. Paul, I think we'll excuse you at this point.
Thank you, Judge.
You are welcome. And we've reset Mr. Miller for plea. Have we not, Missy? We've given him a date.
Yes.
So that concludes our Greenwood County portion of the trial docket. You confirm that, Missy? You are excused, Miss Gillette. Do you confirm that, Missy? You're welcome.
Yes, I do.
Very well. Then we will spend the rest of the docket focused on the Butler County portion. Did Mr. Patterson come back in a position ready to address the jail defendants? Let me know as soon as he is able to do that, please. Chase Miller, I believe you are excused if you're still with us. I saw Charles Miller, but I think he's with another agency. Charles Miller, are you with the Butler County Community Corrections?
Yes, I'm here for John McGee.
Okay.
He's juvenile probation with me.
Well, let me find him among the many here. Okay, that's a Darren Patterson case. Is that a pretrial conference, Jim?
I'm sorry, Your Honor. Could you repeat that?
Well, these are all supposed to be set for pretrial. McGee is just set for pretrial?
Yes.
Okay. All right. Well, let's, thank you, Mr. Miller. It looks like it might be a bit. Ms. Champon, let's take on your client. You said he was for plea, and that's Mr. Moore.
Correct, Your Honor.
Will be on the record now in 2024, BU 2024, TR 1913. Please announce appearances.
Jared here on behalf of the state.
Anna Yumpen, and appears with defendant Philip Moore.
And what announcements, Ms. Japon?
Your Honor, we'll be entering a plea of no contest to the second offense. In addition, there was another DUI that had been transferred over from El Dorado that the county attorneys has declined to prosecute. So we'll just be entering the plea on this today.
Very well. What is the plea agreement?
We'll just go ahead and be entering a plea to the standard minimums.
Okay, so plea discharged and then standard minimum recommendations.
Correct.
Mr. Moore, where are you?
I'm here.
Mr. Moore, I've heard what your attorney said. How do you plead to driving under the influence of alcohol or drugs after a prior conviction?
No contest.
By pleading no contest, do you mean you don't want to admit the charge, but you don't want to deny it and take it to trial either?
Yes.
You understand that means you're giving up your right to a trial. There will be no trial. You'll most likely be found guilty and unable to appeal your conviction.
Yes, ma'am.
Is anyone making you enter this no contest plea today by any kinds of threats or promises?
No.
Very well, Mr. Regier, is it Mr. Regier or Mr. Sweeney on this one?
I am present for purposes of this case, Your Honor.
Mr. Regier, is the state ready to prepare or provide a stipulation of what the facts would be or a proposal of what the facts would be to support this plea?
If the court is prepared to hear it, Your Honor.
I am, thank you.
Your Honor, pursuant to the affidavit, paragraph 4 appears to refer to a stop occurring on July 17th, 2024 at approximately 10:34 in the evening. It appears to refer to a specific location on West Central, just past Denver Street in El Dorado, Butler County, Kansas. Things are saying that is well within Butler County limits, given this court jurisdiction. It would appear that the officer, where this case proceeded trial, would testify that a white Chevy Tahoe was observed stopping in the right-hand lane. Further on in the affidavit, it would appear that the vehicle was observed hitting the curb for a second time. It would appear that pursuant to paragraph 7, the officer attempted to conduct standard field sobriety testing. However, it would appear that the defendant refused. Subsequently, after being taken into custody, the defendant was measured with a blood alcohol concentration of 0.173. That does appear to be well above the legal limit in this case, and the state's evidence would show the same. Additionally, the state would proffer, if the court is prepared to accept it, a journal entry of plea and sentencing in Butler County District Court case 2009 TR 4481. It would appear that pursuant to the same at a hearing on February 8th, 2010, the defendant pled guilty to 1 count of driving under the influence. The opening paragraph of the journal entry further indicates, quote, the defendant appears in person with appointed counsel Doyle E. White Jr.
The court finds the defendant has knowingly and voluntarily entered a no contest plea to driving under the influence of alcohol, a second conviction. The state has provided a factual basis to support that plea. The defendant is found guilty. Do we have an alcohol and drug evaluation for sentencing, Mr. Pond?
Your Honor, it was received. It was done back in March. I forwarded it over to the state previously.
Very well. Mr. Regier, can you send that to me without much delay?
One moment, Your Honor. Your Honor, I am not personally aware of any drug and alcohol evaluations. So I would respectfully suggest if counsel for the defense can provide that to the state and to the court, this matter should be able to proceed fairly expeditiously.
Well, Ms. Japanin, we can either continue this to another day, although I think it was your intention to resolve it today, or we could put this further in the docket and let you resubmit that evaluation to prosecutor and to the court. what would be your preference?
Your Honor, I am going through my email. I am not seeing it here. I prefer to go to another day just so I know for sure that I have that.
All right, so let's see. Jen, are you setting my sentencings on these?
Yes, I am. Are you wanting this on a control docket?
That'd be fine. Monday morning?
Yes. I have July 28th.
How about July 29th? Did that work for the parties?
No objection from the state, Your Honor.
That's fine.
Very well, Mr. Moore, I'm going to continue your bond with all existing conditions, plus the added condition that you and counsel reappear Monday, July 29th, 9 a.m. for sentencing. You must, before that date, sign any releases and get your alcohol and drug evaluation to your counsel, so she in turn can get it to Mr. Regier and to the court for that sentencing as it is required by law.
Yes, Your Honor.
All right, thank you.
Your Honor, just to clarify that Monday's the 28th, Tuesday's the 29th, which.
Okay, I wrote down the 29th, but I think Jen said the 28th.
Okay, all right, that's what I thought. I just wanted to confirm.
Okay, thank you for doing so.
And
Mr. Moore, the 28th, Monday, July 28th.
And will that be by Zoom?
By Zoom, yes.
Perfect.
All right, thank you.
ma'am.
Mr. Conlon and Mr. Moore are excused.
Thank you.
You're welcome. And Arnold was for dismissal, and Mr. Jensen, you're waiting to resolve your appearance today on Martinez, correct? And we were in recess on that. Mr. Regier, you were going to visit with some of your staff. Do you have any announcements back on the record in 24 CR 13, all parties as before?
Yes, Your Honor, if I may.
Please.
Your Honor, the state's understanding is that my office has been in contact with the victim as recently as within the last 2 weeks. So the state's understanding is that any lack of service of a subpoena insofar as the victim is concerned is a non-issue. However, the state is not prepared to proceed in this case absent the testimony of Officer Weekly. So for that particular reason, there does appear to be a witness issue and the state is requesting a continuance.
Do you know where your witness is, the officer? If I continue this, in other words, will you find him?
That would be the state's intention, Your Honor.
I know it's your intention, but do you have any reason to believe you can find him? From what the response said on that subpoena, I'm questioning that.
Your Honor, based off my notes in the file, I believe the state will be in a position to proceed with the testimony of Officer Weekly if this court is prepared to grant a continuance in this matter. I would also note that this matter was previously set for pre-trial. However, it would appear that the court did revoke the defendant's court-appointed counsel upon statements of court-appointed counsel Darren Patterson at the time, and the matter was continued, and that and then the court had previously made findings that all prior continuances were assessed to the defendant for speedy trial purposes as of a misdemeanor control hearing on February 10th.
No, we've had 9 hearings in this case, the first one being January 8th, 2024, which is quite troubling. Attorney Jensen did appear with the defendant 210. That appears to be the first time after he took the case, after the defendant retained him. All right, so the state needs a continuance. Mr. Jensen, your response to that request for continuance?
We remain for trial today, Your Honor.
Well, I am going to reluctantly grant the continuance because the defendant has had so many continuances of his own. He had a misdemeanor control 1, 2, 3, 4, 5, 6, 7 misdemeanor controls. And I realize you weren't counsel of record at the time, but I'm going to grant over objection the continuance. But I will note that it is over objection of defense. But I anticipate it will be the only continuance granted to the defendant, particularly on these reasons. At this time, we need to reset that, and my next jury trial date will be October 19th pretrial with 21st and 23rd trial. Isn't that correct, Jim?
October 19th, it's a Sunday.
The next,
right.
The pre-trial is September 29th with jury October 1st and 2nd.
Okay. September 29th, and your jury trial will be October
1st and 2nd.
Second. Okay, 1st and 2nd. I'll continue the bond, Mr. Martinez, but you are to continue with the existing conditions and reappear ready to go to pretrial September 29th. 9 a.m. we will begin. So be here by Zoom. Jury trial will be live in person beginning 9 a.m. October 1st and 2nd. Nothing further. Mr. Jensen and Mr. Martinez are excused.
Thank you, Your Honor.
Thank you. You are welcome. Anyone else for plea? None of you could work out a disposition, or did you not consult?
Judge, I do have a number of cases ready for plea if you're ready to start taking those.
I am. In the meantime, I would urge breakout rooms for anybody that hasn't attempted to resolve your cases short of jury trial. James Watts, have you talked to the prosecutor about Neil Beeman?
I have not, Your Honor. I expect that one's going to proceed to trial.
Okay, is that tied to a felony, or is the felony resolved? Did someone tell me you resolved
The felony was dismissed some time ago, was transferred back to this court.
And Judge, if you recall, I have a Beeman case also. Mr. Watts has a Beeman case. Would it be all right to put the three, Mr. Regier and me and Mr. Watts in a breakout room real quick, talk about those?
Let's go ahead and do that. That's the only one on Mr. Watts' docket, on the docket with Mr. Watts. Jan, would you please put the prosecutor, Mr. Regier, and the defense counsel, Darren Patterson and James Watts, in a breakout room on Beeman? And Attorney Weishman's case on Capps has already been reset, correct, Jen?
Yes.
Okay. And that brings us to, how about, and the Fleece case also, well, are they here, or did we go ahead and journalize that, Miss Norris?
That one's been journalized and has already been taken care of. Your Honor, you just mentioned PAPS.
I don't know that I did, but I certainly will.
Well, you just were talking about Mr. Weishman's case?
Oh, yes. I'm sorry. Yes.
Was that PAPS?
Caps with it. Yeah. Caps with a C.
Caps. Oh, I'm sorry. Because I just wanted to clarify.
Well, I think we have a PAPS on here too. So that was
we do.
And is that your case, Michael Paps? It's a Darren Patterson case, however.
No, Your Honor, it's actually Mr. Sweeney's / Mr. Regier's, but it's also Darren Patterson case. So
okay,
it's a possession of marijuana case. But yeah, I think without Darren, we can't proceed.
I think you're right. Do you have any, Miss Norris, that could proceed for plea or otherwise dismissal?
Your Honor, there are notes in several cases, but I don't think any of the ones left don't belong to either to Darren. I'm not sure if anybody else is represented by any other attorney
Okay,
at this point.
I see what you're saying. Very well. So we'll just wait till Mr. Patterson comes back, because yes, it looks like they are all his from here out. All right, I'm going to close my screen and my microphone for just a moment till they come back. Mr. Patterson, are there any announcements on this matter?
Your Honor, after discussions, we have initiated plea negotiations. Mr. Regier has stated he would consider those, but is needing additional time. I'm not sure how much time he is needing for that, though.
Well, Mr. Regier, how much time do you need?
Your Honor, hopefully it would not be a particularly long endeavor, but again, I was not aware that any prospective plea negotiations could be made in this case until approximately 30 seconds ago. So I will need the opportunity to consider both these matters together before I am in a position to respond.
Can that be accomplished today at some point in this docket if you're given enough time?
That would be the state's hope, Your Honor.
Very well. Do you need to take that time right now? And maybe I can use Mr. Patterson for some of these other defendants that are clients of his and another prosecutor?
Your Honor, if the court wishes to take both these matters up later on, perhaps towards the end of the docket, I don't think the state would have any objection.
All right. Do you need some time now, though?
If the court is prepared to grant it, I understand my colleague, Ms. Norris, and Mr. Sweeney will be called into other courtrooms momentarily before certain district court judges.
All right. Well, why don't you take what time available now, and I will see what I can accomplish with the other prosecutors before they have to leave to the district judges. How about the gentleman in jail? Mr. Patterson, are either of them ready to go?
Kyle Hughes, Your Honor, if we could do him, he's in custody.
All right, let's take up Mr. Hughes on the record in 2024 CR 513, State of Kansas versus Kyle David Hughes. Please announce appearances.
Amber Norris for the state.
Your Honor, Darren Patterson appearing on behalf of Kyle Hughes. Mr. Hughes does appear from the Butler County Jail. Judge, this is a case where my client is charged with theft and driving while suspended second. I have met with Mr. Hughes in jail. I've also reviewed basically everything going on with Mr. Hughes. He does have other Butler County cases that are set for jury trial pre-trials in July, as well as prelim in June. These are all felony cases. Judge, this is a case where I am asking the court to allow continuance of this jury trial to work on basically plea negotiations on the mixing it in with the felony cases, if that can be accomplished. Otherwise, this continuance would be at the speedy trial for purposes at the defense request, and would ask that it be set down for the October date for jury trial if we can't work anything out. But I think we probably could, Judge.
Do you know who the July jury trial is before, which judge?
I'll leave that to Ms. Norris. I don't have that right in front of me. I do have down that it's July 1 pre-trial, July 8 jury trial.
One moment, Your Honor.
Very well.
And Your Honor, we have been working towards resolving all of Mr. Hughes's cases. He's got, I think Mr. Patterson makes 3 attorneys and possibly, and I think at least 3 judges. So it's we're still working on kind of coordinating the final plea, but I think that's going to happen.
What I'm wondering is if we could impose upon Judge Hart to maybe put this with the July jury trial?
Your Honor, the pretrial actually is on Tuesday, the 1st. I don't have any problem with that, if Mr. Patterson doesn't.
And
I would think that would be all right with Judge Hart, so that I would contact his office and see if we could use the pretrial date, July 1st, to put this on there also.
He's generally pretty gracious and accommodating, and I hate to presume or take advantage of that, but if he would do that, I would like to continue this to the pretrial date of July 1st. If we think that that's reasonable to expect an agreement among the cases by then. Ms. Norris?
I do, Your Honor.
Okay. All right. Janet, well, let's tentatively put this on Judge Hart's docket, July 1st pretrial and then his jury trial.
This courtroom hearing takes a serious turn as the defendant faces the consequences of a case that has now reached a critical stage. The court carefully reviews the circumstances, the arguments from both sides, and the defendant's position before deciding what should happen next. What makes this moment especially important is that the defendant's future could depend heavily on how the court views the evidence, the seriousness of the allegations, and whether the defendant has shown genuine accountability. At the center of this courtroom hearing is Michael Winquist, a defendant facing extremely serious allegations and multiple criminal charges. Both the prosecution and the defense had reached a proposed plea agreement and asked the judge to approve it. But from the very beginning, the judge made it clear that this was not going to be a routine approval. She explained that accepting a plea bargain is not automatic. Even when both sides agree, the court still has a responsibility to decide whether the agreement truly serves the public interest. The judge described the decision as extremely difficult. According to the allegations and information before the court, the case involved serious physical and emotional harm, including the impact on a juvenile. The judge explained that she had reviewed the criminal complaint, hearing transcripts, the defendant's admissions, arguments from both attorneys, and an impactful statement from the victim. But after considering the entire proposed agreement, the judge said she had serious concerns about whether the deal was appropriate as a whole. One major concern was the defendant's alleged conduct and history. The court noted that Winquist was on active probation and subject to an absolute sobriety condition. The judge also stated that as a convicted felon, he was legally prohibited from possessing firearms. Yet the information presented to the court described allegations of frequent intoxication and multiple firearms being kept in and around his home, including a loaded firearm near his bed. The judge concluded that this combination created a serious risk to both the defendant and the community. The proposed plea agreement would have significantly reduced the charges and potential punishment. While the parties agreed that the original charge in count 1 might not